Welcome everyone. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. I'm Senior Staff Attorney Susan Ingalls here with our producer Kenneth Elliott. We're in the background, and you are viewing Ashini Shrivastava, a staff attorney with the Center for Heirs Property Preservation here in South Carolina. We're observing Black History Month, and Ashini will be discussing the experience in South Carolina when it comes to untangling the title to property when there are multiple heirs to the same property. This is a problem that is really most often faced, I think, by Black families here in South Carolina, but others as well. And so Ashini will be talking about the problems associated with heirs property, how they arise, what you can do, and the services that the center provides. So thank you so much for being with us, Ashini.
Thank you, Susan. Thank you for having me today.
You're welcome. But before we get started, we do want to remind everyone that this is not legal advice. It's just general information for the public. If you need the help of a lawyer, you can call our intake line here at South Carolina Legal Services or apply online, and that information will be provided at the end of today's presentation. You see right now a QR code on your screen, and that's where we ask our viewers to suggest an episode of Level Up Law. There's all kinds of topics. We've covered a lot of them, but there's plenty more to cover, so please do take a moment right now as I am introducing Ashini to scan that code and see if you can give us your thoughts on what topic you might like to hear about. Also, as a reminder, all of our episodes are posted by our producer, Kenneth Elliott, to the Level Up Law playlist on our YouTube channel, usually within about 24 hours. For today, Ashini can answer general questions if there is time, of course, at the conclusion of today's presentation. So do put any questions you have in the question box, not the chat box, just the question box. Also, just a quick reminder before we get started, be sure to check out our social media. We are on all platforms, whether it be Facebook, Twitter, Instagram, LinkedIn, and even TikTok. So all of that information, again, will also be provided at the end of today's presentation. So without further ado, welcome Ashini, and let's get started on the Center for Heirs Property Preservation.
Thank you, Susan. Good afternoon, everyone. It is a pleasure to be here with everyone today. My name is Ashini Shrivastava, and I'm one of the staff attorneys at the Center for Heirs Property Preservation, and it's a real honor to be here to talk about what the organization does and what our legal department does. Before we start any presentation, we love to bring up this proverb. If you want to go fast, go alone, but if you want to go far, go together. We think it's really important to start any presentation about heirs property with this quote because we really want to emphasize the importance of working together. When it comes to family land, heirs property, if everybody is on board working together, everything is going to go that much more smoothly, and any issues that there might be will be resolved in a much more quicker fashion. So that is what I want to start off by saying. If you want to go far, go together. So what I hope that everyone takes away from this presentation is a proper understanding of what heirs property is and how that affects the owners of heirs property. I also want to let everyone know what the steps are that they can take to preserve ownership of the property for all of the future generations of the family. If there are three main key phrases that I would like everyone to remember, it would be family agreement, the importance of having a last will and testament, and the importance of probating an estate. So let's get right into it. So what is heirs property? So this, what you have on the slide in front of you, is a very legal definition of it. So the owner of the property on the last deed has died more than 10 years ago. that person's estate was not probated, and we'll go into what that means in just a bit, but no appropriate legal action has been taken since the last owner on the last deed has died. So that is what heirs property is. The last owner that is recorded on the deed has died for more than 10 years, and there has been no appropriate legal action taken since. So what does that mean? When in South Carolina, when somebody passes away and no legal action has been taken, their heirs now become owners of that deceased person's property. So if we're talking about a piece of land, and let's say we have somebody, let's say Joe died in 1980 and he left behind a spouse and 5 children. So though that spouse and the 5 children are now tenants in common when it comes to Joe's property. That means that all of these 6 people own the property together. They may have a different percent of ownership, but they own it together. If you think of it like a pie, all of these people own the property like a whole pie. This pie has not been sliced, so that means that, as you can see, all the heirs share an undetermined, undivided interest. So the pie has not been sliced, but all of these people own the pie together. So when it comes to, I'm going to step away from the pie for a second, but when it comes to land, that means that all of these owners have a right to fully use and enjoy the property. So, if everybody wants to live on the property, they can. If everybody wants to hunt on the property, they have the full rights and to do that. So everyone can use the pie together. So this is the first instant where family agreement is really important, because if there's disagreements on what to do with the land, then that's obviously going to make everything a lot more difficult, especially since these 6 people in my example are not listed on any type of deed. Remember, the deed still lists the deceased owner in this example, who's Joe, as the owner of the property, and Joe has passed away more than 10 years ago. So these 6 people now have a right to use this property, but of course, if there's disagreement and there's any type of hostility, that would make it much more difficult. So how does this affect these 6 people? So each of these 6 people owns a particular interest, a percentage of this property, but there's no clear title. When we talk about clear title, we mean that on a deed for a property, everybody is still living. So in my example, Joe is the last person on the deed, so there's no clear title to the property. These 6 people are heirs of Joe, but they do not have a deed with their names on it. So what happens is that this type of property ownership is extremely unstable, and it is a liability rather than an asset. I have had a lot of people tell me, oh, that, owning heirs property is an asset. They want the property to stay as heirs property. And I have to explain to them how actually that is more of a liability, and that's really a disadvantage for everyone, because like I said, it is an unsliced pie, so nobody can actually get their specific percent of the land. Nobody can make any type of decisions. If you want to put a house on it, you cannot get a mortgage. You won't get title insurance. If you wish to sell this property, if all the 6 people wish to sell this property, they can get together and do that, but the buyer is going to realize that the last deed lists Joe on it, and so they're not going to get fair market value for their land. When it comes to family agreement, if in these 6 people, even one of the owners is disagreeable or for some reason wants to do something very different from the other 5, any one of these owners can force a sale of the entire property. Now, if everybody wants to sell the property, of course, that's the best case scenario. But if everybody wants to keep the property for future generations to use, then of course, that is the worst case scenario. You'll see we've written predatory development on there. What that means is it's kind of like the for sale. Any of these 6 people can sell their interest to a third party outside of the family. So if the spouse of Joe wants to sell her interest to a developer that wants to build condos or something on the property, she can do that, and then that developer can force the sale of the entire property and legally own it. So again, if the end goal is to preserve family property, if it has been passed down through generations, then this is worst case scenario. Threat of tax sales. We have seen commonly when it comes to heirs property and family land, usually there's only one person paying taxes on the property for decades and decades. Now, this is not actually the way things are supposed to be. Since there are so many people who own an interest in the property, technically they should be sharing in the losses of the property equally. So whether that's taxes or maintenance of a house or maintenance of the land, everybody should be paying their fair share. However, that's not always the case. So there'll be one person paying the taxes on everything, one person paying for all the maintenance, and so on. When that person passes away, sometimes the family members forget that that person had been paying the taxes on this family land for all these years. And so what happens is the taxes are overdue, and then the property goes to tax sale, and then the property is lost from the family forever. So, it is difficult when it comes to heirs property, especially when we have family members that live all over the country, live all over the world, and they may not even know that this piece of land was in their family from 2 or 3 generations ago. So they didn't even know that this property existed, and now it's been sold at tax sale and they can't do much about it. So this is where owning heirs property is actually a really unstable form of land ownership. What steps you can take? Let's go a little bit more positive now. So the Center for Heirs Property Preservation, we are a nonprofit, and our mission is to help families resolve these title issues and to keep the family in their land. We offer intakes to everybody who needs advice about heirs property. And since we are a nonprofit, we do not take any legal consultation fees or any such thing. We don't take any attorney's fees. So anybody who thinks that they have heirs property in the family, or they just want to get some advice on how to deal with the situation, they can give us a phone call. Our information will be on the last slide, and you can schedule a phone intake. If you don't have to come into our office, everybody is entitled to a 1-hour legal consultation with our attorneys, and we will walk through what you need to do, or what we'll try to assess what the situation is. If during that phone call we see that you qualify as a client, then we will walk that journey with you. But this is the simplest thing you can do. Just schedule an appointment, a phone appointment with us, and we will kind of figure out what's going on and what you need to do. We do have 2 offices. Our main office is in North Charleston, and we do have a satellite office in Orangeburg as well. So if you do want to come in for any reason, or you wish to schedule a will appointment or get some other type of estate planning document drafted, those would be the 2 locations that you would come to. Second step, getting your will drafted. If you own any type of property, land, cars, mobile homes, if you think there's heirs property in your family, either from either of your parents' side or grandparents' side, get a will drafted. That is another thing the Center for Heirs Property can do. We do draft wills. And of course, if you have another attorney that you are familiar with or that you've worked with in the past, definitely get your will drafted. That is the easiest thing anyone can do when it comes to resolving heirs property situations. The third thing is probating your loved one's estates. I believe we'll go into that in the next slide. So I'll go through what exactly that entails. But basically, a will is only valid for 10 years after someone dies. So if someone has passed away and they had a will, the family and the executor of that will has 10 years to get that will to the probate court and to start that process of transferring property out of a deceased person's name and into a living person's name. We'll go into that in a little bit more detail. Family agreement, here's that phrase again. At the center, we do have certified mediators on staff. And so if there's a situation where the family wants to move forward, majority of the family wants to move forward and they want to, resolve the heirs property situation, but there are a couple of disagreeable family members, you can give us a call and we can help you try to get the family on the same page. Like I said, if you want to go far, you go together. To getting everyone on the same page will just make things that much easier when it comes to any type of legal action that needs to be taken to clear the heirs property status of a piece of land. Let's go into wills really quickly here. The requirements in South Carolina is that you have to be at least 18 years of age to make a will. You have to be of sound mind. Your will has to be in writing. There are a lot of people who call and say, oh, but my grandmother told me this. If she didn't write it down, it doesn't matter. A verbal will is not allowed in South Carolina, so it has to be in writing. It needs to be signed by the testator, who is the person making the will. So the person making the will has to sign it, and the will has to be witnessed by two disinterested witnesses. Disinterested witnesses are people who are not inheriting anything from the will. So if somebody makes a will and they're leaving all their property to their kids, the kids cannot be the witnesses. It has to be someone disinterested who's not inheriting from the will. As an added layer of protection, we do advise that the will be notarized, as if there's any question to the witnessing or anything, that notary level of protection will be helpful when it comes to actually executing this will. Other things that people can do when they're thinking about planning for after their lives is a durable power of attorney and a healthcare power of attorney. These are two documents that the Center for Heirs Property also drafts on site at either of our two offices. A durable power of attorney is kind of like appointing a financial agent for yourself. So if you are not able to make any decisions when it comes to your bank accounts or your land or any of your assets, this agent that you appoint through this document will be able to make those decisions on your behalf for your best interest. So that is what a durable power of attorney is. It is valid for the duration of when you sign the document till the end of your life. It is invalid the day you pass away. A healthcare power of attorney is kind of what some people refer to as a living will. This is where you go through sort of difficult decisions of, what you would like if you were incapacitated in a hospital or nursing home setting. What kind of care would you like to receive, and who would you like to make decisions for you when you are no longer to make those decisions for yourself. So that is what a healthcare power of attorney is. And again, we do draft these two documents as well in our offices. The benefit of having a will. If you have a will and let's say, you have many children, but some of those children live out of the state, some of them live abroad, you get to decide who gets your property. So if you have a piece of property in South Carolina, for example, and you have 6 children, but only one of those children really wants the property and is going to live on it and take care of it, you can actually leave that property to that one child. You don't have to leave it to everybody. You basically get to put your intent in writing so that nobody can really argue with it after you have transitioned from this world. You also get to decide who will be your personal representative. So personal representative and executor are synonyms for each other. They're the same thing. This is the responsible person that takes your will to the probate court after you have passed away to start the process of transferring your assets from your name to somebody else's name. So they just have to be a responsible person. So you do have to think hard about who you want this person to be for your assets after you pass away. And again, you can decide who you want that to be in your will. At the bottom, we've listed it must be probated within 10 years or otherwise we'll have another heirs property situation. So without further ado, what is probate? Probate is a legal process. It happens in the probate court of either the county that you reside in or the county that you have property in, real property, land, or have built home or something like that. It is basically a process which transfers the title of any property out of the deceased person's name and into the living person's name. So in South Carolina, it is mostly a form-driven process. Only in very rare circumstances are hearings necessary, but it is a form-driven process. It's quite straightforward to do if you understand kind of the order of the forms. And yeah, basically we're just getting the deceased person's name off of any property and putting the property into living people's names so that those living people can now actually take decisions for the property. we've listed testate and intestate. So if somebody has passed away testate, that means they passed away with a valid will. If they passed away intestate, that means that there's no will on record, that person never made a will, and that's when the South Carolina intestacy laws come into play. So what that means right now is if somebody passes away without a will, if they had a spouse and children, the spouse would get 50% of the property and their children would get the other 50%. If they didn't have any children, the spouse would get everything. If they didn't have a spouse, the children would get everything. And if they don't have a spouse or children and they don't have grandchildren or any descendants, then it would go up the family tree as per the South Carolina laws. So it would go up to the parents level. If the parents are deceased, then it would go to siblings and then nieces and nephews, and it would, there's a whole chart. So if anyone's really interested, y'all can look up the South Carolina intestacy laws to see how the court determines who are your heirs. The point of probate is it's easy, it's form driven, and it easily takes property out of a deceased person's name and preserves the chain of title. Chain of title is just you see the chain of who owns property. So person A owns a property and they passed away and their probate was done, then person B now becomes the legal owner of the property. So there's a record of who is the owner of the property, and this helps in keeping that chain of title for future generations and for, to figure out who are the decision makers of any property. In South Carolina, the law is that probate has to be done within the first 10 years of the decedent's death. So there's a deadline. There are other states in the United States that don't have a deadline, but South Carolina does. So that means if you have a will, that will is only valid for 10 years after you pass away. And if you don't have a will, but you still want to do this simple process, it has to be done within the first 10 years of the decedent's death. Who are the heirs? So I talked a little bit about the South Carolina laws of intestacy, and if there's a will, of course, we don't really need to figure this out, but if there's no will and it's more of a complicated family, then we do need to create an accurate family tree. So our recommendation for everybody is to start with the person named on the deed at the top and then work your way downwards. So you need to consider whether there was a legally married spouse, whether there were children within the marriage, whether there were legally adopted children, whether there were biological children outside of the marriage, and then who the parents and siblings are, just so you can see who will be inheriting from this person who died without a will. We have a little sample family tree over here, so I'm not going to get too much into the weeds, but we can see there's an owner, and they had 4 children. 2 of those children are still living. So child B and child C are still living, which means they are the heirs. They are 2 of the heirs. Child A passed away before the owner, leaving behind 2 children of their own. The grand 2 passed away as well. So now there's a great grandchild. So you can see that the grand 1 and the great grand A are also heirs now because other people have passed away. With child E passed away, and they did not have children of their own, but their spouse who passed away after, they had a child. So now you can see how the stepchild comes into the picture and becomes is entitled to some interest in this property. So all of the bright green boxes, so grand 1, great grand A, child B, child C, and stepchild, these are all the heirs of the owner. So you can see how listing out all of the members of the family and also listing out their dates of death is really important to figuring out who inherits. I just want to take one moment to mention child C has 3 children of their own. So there's 3 grandchildren there, but they are not heirs yet because child C is still living. So those 3 grandchildren will only inherit if child C passes away. Until then, they are just descendants. They are not heirs. So I'm distinguishing between what an heir is and what a descendant is with this example. Clearing the title. So we talked about the importance of having this paper trail which shows, okay, person A owned this property, then they died, their probate was done, now person B and person C now own the property. If they die, then we need to figure out who owns the property. So going through the process of probate really establishes that paper trail that is necessary to figuring out who owns a piece of property. Again, two of the easy things to do while you are still living. One easy thing to do while you're still living is to make a will, so that you can indicate who you want your property to go to after you pass away. And then after you pass away, the easiest thing to do is go have your family members or your executor do the probate for you and that property to get it out of your name. There are some people who know that they have an ownership interest in property while they're alive, but they don't want anything to do with that. So what they can do in that situation is that they can sign a quitclaim deed over to whoever they want to give the property to. So for example, let's say I have a sibling and we both have interest in Heirs Property, but she doesn't want anything to do with it anymore. She can just sign over a quitclaim deed to me. This type of deed is basically making no warranties or assurances. It's just saying whatever I own in this property, I sign over to you. It's not even saying exactly how much you own in the property. It's just saying, I have ownership in this property. How much it is, I don't know. I sign it over to you. So this is something that a lot of people do when they want to leave the pie, so to speak, that heirs property pie. They just sign over quitclaim deeds to other people, signing over their interest. I wanted to stop briefly to just mention that plats, which is a survey of a property, and tax bills are not deeds. So I've had countless people tell me that, oh, I have my name on the tax bill. That means I'm an owner of this property. And oh, there used to be somebody else's name on it. They removed their name. I put my name on the tax bill. That is not a deed, and that does not show ownership of property. The deeds office and the tax office are two separate entities. The tax office putting your name on a tax bill just means that you will now start getting the tax bill. That does not mean that you own the property. Similarly, with a plat, which is a survey of a property showing the boundaries and things, people say, oh, my grandmother, she partitioned the property and she drew up a plat saying this portion goes to Jimmy, this person goes to Bob. Again, that does not mean that Jimmy owns that one section and Bob owns the other section. It's just showing a drawing. If there is no deed on file, that is not a valid transfer of land. So just wanted to mention that up front. Now, we talked about how probate has a 10-year deadline. So what happens after that? So there are two types of legal actions that could be necessary for the piece of heirs property. Both of these actions the Center for Heirs Property does assist with. The first one is called a petition to determine heirs. We like to think about it as a fancier probate. So with probate, it's just form filling and filing the forms at the right time. With a petition, it's more formal. There has to be a hearing. And what we're basically doing is we're asking the judge, the probate judge, to determine who are the heirs of this person who passed away more than 10 years ago. So these types of actions, these petitions are usually used when not too many people have passed away. So in my example with Joe, who passed away and he left behind a spouse and the 5 children, if no probate was done and the spouse and the 5 children are still living and it's been 12 years since Joe's passing, then a petition would be the right action to use because everyone's living. The judge will just say, when Joe passed away, his wife was living and his 5 children were living. They are now the heirs to Joe and they will inherit whatever property that was in Joe's name. And the judge will also establish the percentages that each person owns. So that is what a petition is used for. A quiet title is a lot more extensive and it comes in handy when there's lots of generations who have passed away since the person listed on the deed. So, I have a situation where, you know, the deed holder passed away in about 1910. And so there's 3 generations of people that we're working with, and a lot of people have passed away, leaving heirs of their own. So a quiet title is a way to consolidate all of those probates and petitions that were not done, and to do it into one legal action to say who are the heirs of this person who died in 1910, for example, and what is each of that person's ownership. It's a much lengthier process. It's more involved. It's not the easiest thing to do, but that is the legal action that is used when the deadline to probate has passed and when it's not appropriate to do a petition to determine heirs anymore. Partitions of property. A lot of people get frustrated when the pie has not been sliced. So they want the pie to be sliced, especially when we're talking about, you know, 50 acres of land or 60 acres or more. Everybody wants their own piece of the pie. It is very important at the center. We really recommend that the title be cleared first, either through a probate, the petition to determine heirs action, or a quiet title. The reason that we say clear the title first is because if you partition a piece of heirs property, all you're doing is creating more little parcels of heirs property. If there's, you know, if Joe owned 50 acres and you made 50 partitions of 1 acre each, all of those partitions, the legal owner is still Joe. So you must get Joe's name off it first if you want to then have each person own their own slice of the pie in their name. So we do recommend getting the title cleared first before engaging in any type of partition. There are 3 types of partitions that are possible when it comes to land and heirs property. One is the physical kind, so partition in kind. That's physical slicing off the pie. The second type is partition by sale. So that is when you sell the property and then the financial proceeds are, you know, distributed among the heirs or the owners as per their percentage. Partition by allotment is kind of a hybrid. So this is where, let's say there's 20 heirs that have an ownership interest in a piece of land, but 10 of them don't want the property, but the other 10 do. The 10 that want the property can buy out the other 10, so that we're consolidating ownership, and then only the people that really want the property, they can then physically partition it out. The Uniform Partition of Heirs Property Act, this is in South Carolina, it's also referred to as the Clementa Pinckney Act. There's a little bit of a misconception about this act, which is why we wanted to talk about it. This act only applies if property is being partitioned. So there were a lot of people when this act came out that they thought, oh, this act is out, you know, the issue of heirs property is no longer an issue. That is not correct. This act only applies if a piece of property is being partitioned, and there are lots of pieces of property where the family does not want to partition it. So it doesn't apply in those cases. And the only real, not only, it's a very important focus. This act is very important for putting people on notice. So it has a lot of stringent requirements about giving notice to all of the potential heirs of a piece of property, putting signage up on the piece of land. It does not change the need for anything that I just talked about. So it does not change inheritance rights if there's no will. So it does not change the South Carolina laws of intestacy. It does not change the need for having a will or to do a probate after you've passed away. It does not change the need for full agreement among the heirs. It just makes everything much easier, and it does not prevent any forced sales or any heirs property issues. So we'd just like to let people know that if they did have this misconception about this law, that this act, that's not the case. It only comes into play when a piece of property is being partitioned. I have thrown a lot of information at everyone today, and so at this point, Susan, if there are any questions, I would love to take them.
That's awesome. Thank you so much, Ashini, for a great presentation. It looks like right now we don't have any questions. Maybe you just answered everything. It was a great, very, covered everything, I think. Any question I certainly had has been answered. So thank you so much for that. I'll keep an eye though on the question box here for just a few more minutes, but I do want to thank you. It was a terrific presentation, and you know, we really do at South Carolina Legal Services. We appreciate so much what the Center for Heirs Property Preservation does for the people of South Carolina. It's one of our real gems here in our state, and you know, I know that y'all are nationally recognized for what you do. So props to you guys for that and for all the good work that you do. And I also want to thank our audience for today for joining us here each week. And also, if you're just on the YouTube replay, thank you for joining us there and for checking out this great presentation about heirs property.
So I do have the Center for Heirs Property contact information up. So if anybody does have any questions about heirs property or thinks that they want to schedule a legal consultation, again, it would be done over the phone. Whether you live in the state or outside of the state, it doesn't matter. If there's heirs property in South Carolina that you would wish to discuss, you can give us a call and schedule an appointment with one of our attorneys. We also have our website up here. So if you want to just see what more the Center for Heirs Property Preservation does, you can just get the whole picture on the website. And thank you again, Susan, for having me here and for allowing me to share what this organization does.
Well, thanks for that. And I really do encourage any of our viewers that have an heirs property issue to reach out, as you just mentioned, and you know, see if the center can help with their heirs property issue. You guys do a fantastic job. So here's a final slide with all of our information for legal services in case any of our viewers are having a legal issue, or if you just want to follow us on social media. It's a great way to find out what we're doing here at South Carolina Legal Services. This is where we share our resources, not just videos like this on YouTube, but we put out information not only on our websites, but also on social media on a regular basis. Again, here is the QR code for signing up for our newsletter. So I encourage everyone to scan that code and sign up for the newsletter as well. So let me also say to our audience, if you found today's presentation helpful, and I'm sure you did, and if you know it might be helpful to others, someone you know, even if you don't have a problem like this, someone you know may have an issue, you know, you definitely want to share this out from our YouTube channel. We really want to make sure that as many people as possible get this important information about heirs property. And of course, while you're there, be sure to like and subscribe for more, and sign up for you know, notifications, so that every time we post a Level Up Law episode or any other video that we might post, you'll get notification of it. And also, before we sign off, I want to remind everybody to tune in next week for another episode of Level Up Law on Tuesday at noon. We will be having David Mahatha, the Director of Diversity, Equity, and Inclusion from the University of South Carolina School of Law, and his topic will be building a culture of belonging for law student success. David is the director of the DEI program at the law school, and they're doing a great job at USC Law School with diversity, equity, and inclusion. So definitely join us for that. But again, Ashani, great presentation. Thank you so much for being with us. Thanks to our viewers, and thanks for tuning in today, and always on Level Up Law. That concludes today's webinar. Thanks, everybody.
Thank you all.